Wow, panic has set in. I have to appear at a hearing that is known as the first meeting of creditors, also known as the 341 hearing. There is no need to panic. If you live in the Bronx or Manhattan, the hearing is held in Manhattan at 80 Broad Street, an office building, and you go to the 4th floor. Take the number 4 or the number 5 train to the Bowling Green stop. It's only 2 blocks away. If you live in Westchester or Rockland County, the hearing is at 300 Caropus Street in White Plains. This is actually in the courthouse in room 243A. If you live in Dutchess, Putnam, Sullivan, or Orange County, the hearing is at 355 Main Street in Poughkeepsie. Generally, you appear only once with your attorney, and generally no creditors appear. The hearing is conducted by an attorney and not a judge. The trustee asks you questions about the petition that your attorney filed on your behalf. The questions relate to your assets and liabilities and your income and expenses. The questions should be quite familiar to you if you were represented by competent legal counsel. They all relate to the information provided in your petition. Sample questions are the following. Have you ever owned a house, co-op, condo, land, or timeshare in this country or outside this country at any time in your life? Have you transferred or repaid monies to family or friends during the last year? Are you suing anybody with regard to an automobile accident or with regard to any other legal matter? Do you own a business or have you ever owned a business? Are you expecting an inheritance? If you have some complicated issue or issues or unusual circumstances surrounding your case, you should expect to be questioned about this. If not, and you have been truthful, things tend to go smoothly as a general rule. The most important element of this hearing is full disclosure. If you have provided full disclosure in your paperwork, there is nothing to worry about. If you're withholding some important information or trying to game the system, you can be in for a rude awakening. The trustee is hired by the Office of U.S. Trustee, Department of Justice. There are a battery of attorneys and accountants to review and audit the paperwork. Remember this adage, if in doubt, disclose, disclose, and disclose. The trustee directs his questions to you and does not direct the questions to the attorney representing you. The attorney does not plead your case. The attorney's work is truly done by diligently preparing the petition with your assistance, providing the trustee with all required documents, and properly preparing you for the hearing. In almost all cases, there's no need to appear again. If all documents have been provided and all questions have been satisfactorily answered, the trustee will close the case. This means that the final paperwork should arrive in approximately 3 to 4 months from the hearing date. That document is the Chapter 7 discharge signed off by a judge. Hold it tight. This is your ticket to the big dance. A fresh start. Congratulations is then in order.